that takes us through the municipal judge. That gets us to public hearings. But before we do that, we have counsel here to speak on the CodeNext petition item number 90. And the question was, do we want to take his testimony, the attorney who's here?
Is that not one that Councilmember Alter wanted us to wait on?
She said that she was okay with us taking testimony, but making sure that we didn't take votes. In fact, my sense is she would rather us move through as much of the stuff as we can before she comes back. It's just someone that's counsel that we're paying to be here, so I thought we might just call them up to explain to us. So I'm going to call item number 90 for that purpose. I'm going to bring up counsel. On item number 90, which is the question of the petition, there was a memorandum that you had written, Mr. Heath, that somehow or another made it into the public domain. So there's no privilege associated with that right now. So without waiving any privileges and speaking to the matter that was made public, can you walk us and the community through your analysis and recommendation?
Yes, sir. And I certainly understand that when you have a petition submitted under a process provided in the charter and it's signed by thousands of citizens, that's something the council takes very seriously. However, our legal analysis is, and our legal advice is, that a comprehensive rewrite of the Land Development Code is not a topic that can be included in a citizen-initiated petition. The state law and cases interpreting state law in Texas dictate that zoning ordinances have been withdrawn from the initiative process. The Supreme Court almost 100 years ago said initiative and referendum do not apply when state law or charter provisions provide inconsistent procedures for passing an ordinance. About 50 years ago, a Texas appellate court specifically said that zoning, because of the statutory requirements for notice and hearing that have to be complied with before you pass zoning ordinances, is outside the scope of initiative and referendum, and that you can't hold an election to pass anything, any sort of zoning ordinance. As a result, in 2003, just to summarize, or a court, Texas court, appellate court, summarized the law by saying the Texas Case Authority historically prohibited the use of initiative and referendum with regard to zoning. Therefore, the petition that you have before you, while properly validated by the city clerk, contains an ordinance that you are, under case law, you are unable to adopt, and that you are not authorized to put to the voters for an election. Now, obviously, Article 4 of the Austin Charter reserves the people the power of direct legislation by initiative and allows people to propose any ordinance that is not in conflict with the charter, the state constitution, or state laws. Qualified voters gather the required number of signatures of individuals who want to initiate a city ordinance, and they provide the petition with the proposed ordinance to the city clerk. The clerk is required to verify the signatures and certify that the petition is valid. And the clerk has indicated that the sufficient number of signatures were attached. The charter requires that when the council receives an authorized initiative petition certified by the city clerk, the council must either adopt the ordinance exactly as set out in the petition, or the council is to order an election for the voters to decide whether or not to adopt the ordinance. The problem here, though, is that state law dictates specific procedures set out for a city to adopt zoning regulations. and initiative and referendum are not consistent with the statutory procedures, and the Texas courts have repeatedly held that zoning decisions, zoning ordinances are withdrawn from the initiative process. Under multiple decisions of Texas state courts, the subject of the proposed ordinance in the petition is one that has been withdrawn from initiative and referendum. Now, there are other legal deficiencies in the ordinance proposed by the petition, but the clearest legal impediment is the very consistent state law that zoning is not subject to an election.
Would you please introduce yourself for the record?
Oh, I'm sorry.
That's okay.
My name is C. Robert Heath. I'm with the firm of Bickerstaff, Heath, Delgado, Acosta here in Austin.
Okay, thank you. Any questions? Thank you very much.
Thank you, Rob.
All right, council, let's go ahead and do the items that we have skipped over. I have the zoning cases and the public hearing cases. Let's do the zoning cases that have been pulled, then we'll do the public hearing cases.